Thank you.
Judge, I have a quick question as
Yes,
well,
sir.
just for clarification. I believe that the amendment that Ms. Massey had offered up limited the build out to 7,000 houses or 7,000 dwellings, and I believe this amendment would also remove that cap. Is that correct?
It would remove it. And there are reasons, if you'd like to hear from our city attorney first before we get into these.
I would like to hear.
Ms. Burnett?
Yeah, our county attorney.
Everybody?
This is the county.
Yes. Can we hear from everybody?
City attorney. Mr. Bullock has got me confused with where I'm at.
Carl Burnett, Pulaski County Attorney. The second amendment that was made, or the amendment to the amendment at the last meeting that limits the development to 7,000 houses, is problematic simply because there's no science to support the 7,000 limit, and I know people will debate that, but it's a number that comes from the TetraTech plan, and actually the TetraTech plan never caps development under. There were two types of design, a conservation approach design, and had you gone under strictly the conservation approach design, which was lot size restriction, the result would have been a little over 6,000 houses because lots were restricted to 5 acres or 10 acres. However, it also allowed for performance standards approach, which is what is in the current set. The best management practices, or BMPs, that you'll hear discussed. And had you followed BMPs, the lot size restriction didn't apply. Therefore, truly, there was no cap in that plan. Had the whole thing developed under the performance standard approach. So the concern is that it may be arbitrary or capricious to set a 7,000 cap where there's no reasonable scientific basis to feel that that's necessary to protect the water. It could be protected and allow more development. So it could be that that cap is overly restrictive. That's one issue.
Absolutely.
The other issue is that it's kind of a piecemeal legislation measure. It was brought very last minute at the last meeting, so it doesn't fit into the current plan. It contains terms that are not defined in the current plan, which may cause confusion if you try to interpret it. It could be determined to be vague. Also, if it's overly broad or too invasive, we may have a taking problem because it's essentially first come, first served. The first 7,000 houses and you're done. After that, people would not be able to develop their property.
Could we not work on the wording?
No.
Since it seems like a lot of it is a matter of words and numbers, language.
Can't fix a turd
like house
with
or
potpourri.
resident.
You could work to design resident. You could work on some of the language. At this date, I think it would be very difficult to work that language into the current plan, which has been years in development.
Thing isn't worth it.
It just doesn't fit with the plan. I mean, the plan that you have in place is not going to set a specific house number cap.
Lawsuit.